Welcome to chapter 6. So now we're looking at the last kind of element of our criminal trials. So we've gone prosecution, defense, judge. Now we're looking at juries. So everybody, under the Sixth Amendment, you have a right to a trial by jury, a jury of your peers, and it's imperative to the system for the fact that it helps with checks and balances for our system. A jury trial is one of the essential prerequisites of free society. And obviously, there are certain ways that we go about picking and impaneling a jury. So jurors, like judges, are supposed to be impartial. They hear the facts of the case and then they make a determination on those facts. However, obviously, there's been questions of the integrity of jurors in the jury system. So we want to look at that. What is their role? So they're in all types of courts, civil, criminal courts, and their goal is, again, listen to the evidence and make determinations. Some states have specific guidelines that create or help create non-biased jury members, but the accused also have a right to waive a trial by jury and take a bench trial or a plea bargain. And in the last chapter, we talked about kind of what the benefits of that would be. Remember, the jury is a group of peers that come together to make a determination. Now, if they cannot make a determination, we'll talk about it in a little bit, but that would be a hung jury, and they would be released, and the defendant could be retried without prejudice. History of juries date back to the Roman Empire and ancient Greeks. And then we've developed a grand jury, which helps get an indictment moving forward with cases to go to either state or federal court. Your book looks at petit jury as well as the grand jury. And King John in 1215 was forced to sign the Magna Carta that reduced the king's power and helped allow due process and jury trials. So how do we pick a jury? So I'm going to kind of shoot through this a little bit, but we first start with voir dire. So your book talks about veneer and the limits that women had on serving in a jury, but we've moved into qualifications that are U.S. citizens, at least 18. You must not have a mental or physical disability that would interfere with your ability to make a determination, and you've never been convicted of a felony. If you're a felon, you're not able to serve on a jury. So voir dire is basically the opportunity for the opposing sides to ask questions to potential jurors and decide if they would like to pick them for the jury. Helps create non-bias, it helps get information about them, and it helps to create your case. Oftentimes people will say the best defense attorneys are the ones that are the best at voir dire, impaneling the jury that is not going to be able to convict your client. You have what's called preemptory challenges, and this allows either side, prosecution or defense, to release someone, and it does not require an explanation. So maybe you don't think an individual is good for the jury, or maybe it's a case where your client owned a type of dog that attacked a child, and that type of dog was a Chihuahua. You are going to want to release anyone that owns a Chihuahua or has a bias against Chihuahuas, because they would be more apt to believe that a Chihuahua would do that. Jury size is about 12. Throughout most of the last several centuries, juries have been comprised of 12 members. In Williams v. Florida, they were convicted by 6-person jury. They also said that 12 members was not in the Constitution, and that they held that was actually constitutional. But we've stuck to the standard of 12. And then juries are also sequestered. So what does that mean? It means they isolate the jurors from potential bias. Now, In regular old trials, the jurors are able to go home, but they are sworn to not be able to talk about the case. In high profile trials, say Scott Peterson, Michael Jackson, they were actually sequestered in hotels so that they were not able to watch television, read the paper, and could be held to be completely non biased. And then once everything's been presented to the jury, they will deliberate and they will create a decision. There's patterns that could be called evidence-driven versus verdict-driven. And we want to stay away from verdict-driven juries because it's going to push the belief that the individual is guilty or not guilty instead of actually starting with the evidence. And again, we talked about we want it evidence-driven instead of verdict-driven. And we want to make sure that they're not looking at stereotypes or other external evidence, that they're actually just looking at the evidence. And then jury verdicts. Obviously, that's when they decide the guilt or innocence of the individual. And there can be jury nullification, where there's refusals of juries to apply the law, or they acquit despite overwhelming evidence, or they ignore evidence. This is when a judge would need to step in and make the determination. And lastly, we're looking at juror misconduct. And one of your assignments this week is to look up juror misconduct and how we can prevent it, whether it be excluding types of technology, or enacting different rules or regulations, trying to avoid from bribery, or discussing the evidence, or lying. But it's definitely difficult to prevent fully against juror misconduct.